Ladies and gentlemen, we're going to call to order this continued hearing of the Milton Board of Appeals on the application of Thayer Nursery to overturn a decision of the Milton Building Inspector. We had a hearing on this matter on October 28th, 2015. We listened to both of the parties and any witnesses and exhibits they wanted to supply the board, and the board began its we closed the hearing and began its deliberation. An issue arose as to a legal issue dealing with the agritourism issue, and we left the hearing open for the limited purpose of allowing the parties to submit memoranda 48 hours before the hearing on the agritourism issue, or any other issue they wanted to address. We did receive a letter from Matthew Dunn, the attorney for Philip Johanning and John Rowe, which I will read into the record in a second. We did not receive any written materials from Mr. DeLuna. We did receive a couple of emails from interested citizens expressing support for Thayer Nursery and this holiday annual crafts fair, as it's been described. So we'll certainly have those as part of the record and give them due consideration. Let me just handle a few preliminary matters before we get into the essence of the hearing. My name is John Leonard. I'm chairman of the Board of Appeals. With me this evening to my immediate right is board member Jeffrey Mullen, and to my immediate left is board member Ted Daber. We're tape recording the proceedings this evening, even though it's being televised. The tape recording here is the official record of the board, so that would ask that before anyone speaks, tell us your name and address. Speak up nice and clear and loud. We have kind of a large room with lousy acoustics, and we want to be sure that we're recording the testimony faithfully, and so that we can revert to the tape recording if we need to, in order to prepare the written decision. Let me. I have a letter from Mr. Dunn. It's a relatively short letter. I don't know, many of the people in the audience haven't had a chance to see this letter at the Board of Appeals clerk's office. That's always a difficult thing to do if you're busy. So I think I'll read it because I think it's an important letter to have as part of the record. It's dated November 3rd, 2015. It's to the Board of Appeals. Dear members of the Board of Appeals, this letter is submitted on behalf of Philip Johanning and John S. Rowe of 23 Parkwood Drive in response to an often repeated argument presented by Thayer Nursery that it is exempt from local zoning requirements under Mass General Laws, Chapter 48, Section 3, which is commonly known as the Dover Amendment. In this reiteration, Thayer Nursery claims that the building commissioner, Mr. Prondak's zoning enforcement order dated September 22nd, 2015 should be reversed because it is subject to the Dover Amendment exemption. There are two fatal flaws with Thayer Nursery's latest attempt to utilize the Dover Amendment. First, this board and two associate justices of the Norfolk Superior Court, Justices Brian Davis and Justice Paul Wilson, have already concluded that the activities undertaken at the Thayer Nursery site are not exempt under the Dover Amendment. If Thayer Nursery now maintains that its primary use of the property has changed to agriculture or horticulture, since the date of these decisions, then it must present this board with quantifiable evidence in support of this assertion. In the absence of such credible facts, a finding that the Dover Amendment exemption applies to Thayer Nursery is simply unjustified and untenable. Second, if the Dover Amendment were somehow to apply to Thayer Nursery, it still would not permit the board to overturn Commissioner Prondak's order because the, quote, products, including but not limited to arts, clothing, ceramics, jewelry, housewares, candles, soap, and carvings that will be sold in the proposed, quote, holiday fair, close quote, or other similar events are not incident to or in conjunction with Thayer's, quote, farming, close quote, activities. Rather, these products will be sold by third-party vendors operating on the Thayer Nursery site. As these third-party vendors are certainly not subject to Dover Amendment exemption, there is no basis for this board to overturn Commissioner Prondak order that they cannot sell their wares at Thayer Nursery site. Despite these shortcomings, Mr. Johanning and Mr. Rowe wish to point out that they would not oppose an application made by Thayer Nursery to the Board of Selectmen seeking a one-day permit that could allow it to conduct a, quote, holiday fair, close quote, at the Thayer Nursery site. However, Mr. Johanning and Mr. Rowe maintain that this board's reversal of the building commissioner's order is not the appropriate avenue to obtain that result, given the prior mandates of this board and the orders of two associate justices of the Superior Court on this very same matter, that is, the inapplicability of the Dover Amendment to the Thayer Nursery site. Virtually yours on behalf of Philip Johanning and John Rowe, Matthew J. Dunn as the attorney for Mr. Johanning and Mr. Rowe. So we'll enter that into order, and we know that Mr. DeLuna is here tonight, and welcome back, Mr. DeLuna. Do you have anything? You didn't submit any additional materials. You submitted a lot of materials on the issue of agritourism at the last hearing, which we've all read and hopefully understand. So let me ask you whether you have any comments to Mr. Dunn's letter, or you have anything else you wish to say.
Both.
Great. So we're not surprised by that.
For the record, Frank DeLuna representing Thayer Nursery. As far as the communication is concerned, with respect to the two cases, and it was acknowledged last meeting that those cases and the ruling of the judge was not on the nursery, the agricultural part of the nursery. It was clearly on the landscape construction part of the nursery. So I think it's a misrepresentation.
Well, maybe a mischaracterization.
Mischaracterization, if you wish.
Thank you.
To say that the judge said that the nursery part was not a nursery or an agriculture.
But are you contending that the primary purpose of Thayer Nursery is indeed nursery?
Absolutely.
Even though Ms. Oldfield submitted affidavits at the 2012 hearing saying that the nursery business was only 30% of their gross revenues?
That's been changed.
Well, you haven't presented any evidence of that, have you? If you have, I
Sure we
missed
have.
it.
We've given you the address of the Canton facility. Your building inspector has inspected the Canton facility. Those issues that were of issue in 2012, the stone, the pipe, all that has been removed, and there's record of that being removed.
I understand
So
that.
the affidavit submitted in 2012 is not relevant to the activity going on in 2015.
Okay, I hear what you're saying, but I don't frankly see that there's been very much evidence on that particular issue, but why don't you continue with
Okay,
it?
the second of all, it's very heartwarming that the abutters are saying they don't, they would not object to a permit by the selectmen, knowing full well that the timing of that would be absolutely impossible.
Why do you say that?
Because this activity takes place in the first or second week of December. If you go before the selectmen, you'd have to make an application, it would have to be published, you'd have to be heard, and a time period for a decision as well as an appeal would have to be over. So it would be virtually impossible to do that within 30 days or 36 days.
Okay, I'm not sure of the procedures because I don't deal with the selectmen and whether the notice requirements are as you say they are. Okay.
And as far as me not submitting anything, last time I indicated that I would attempt to get a letter from the commissioner with respect to this activity from the department. In the short period of time, the commissioner was not able to supply with me, to me a letter. However, the assistant commissioner has accompanied me today, and he is willing to speak with you. You can ask him questions as to the department's endorsement of this type of activity. So if I may present to you Mr. Jason Wentworth. as Assistant Commissioner of the Commonwealth in lieu of a memorandum, and I did report to the board yesterday that I would be bringing them.
No, I understand that. I think the only difficulty that I have is that we do want to dispose of this matter one way or another.
Well, it's for informational purposes for you.
Well, I understand that, but the problem that I have is we're actually in deliberations on the matter. And so if Mr. Wentworth testifies as you suggest he will, Mr. Dunn is not here to, Mr. Johenning's here, but that puts Mr. Johenning in the position that he's then required to ask questions of the Assistant Commissioner, and I'm not so sure.
You can do your
how
questioning
fair
and
that
the
is.
information not be part of the record.
Well, I understand. Let me hear from my colleagues and see how they prefer to handle this. My other concern is I don't want to have to continue this hearing to another night, because that's going to defeat Thea Nursery's issue of getting this decided promptly. And if we have to continue it another week, then it just is stretching things out. And from my mind, I'm not sure what Mr. Wentworth is going to say. I did have a chance to meet him. You introduced him to me. He seems like a wonderful gentleman, but he submitted a lot of materials on this which were read. So, Mr. Mullen, what do you have to say about Mr. Wentworth's testimony?
My main goal tonight is to conclude the hearing so that the hearing will be shorter than the event about which the hearing has been called. That's one of my objectives. I agree with you that we're in the deliberation phase here, but we also have the Assistant Commissioner of the Department of Food and Agriculture sitting here. I mean, he's in the town hall. He probably hasn't been to Milton in a long time, and, there's a certain amount of government courtesy that I feel he's due. So, and I am also prepared to debate the issue, because I learned a lot about agritourism, and I read the code, that also influences what I have to say, because, and I read Mr. Dunn's letter, and I'm not sure that there's much more that Mr. Dunn can say on the Dover Amendment, given how definitive that conclusion was. But I don't want to prejudice anybody, but I appreciated what the letter said. So on that, just government courtesy would say to me, I'd like to hear from the Assistant Commissioner.
Okay, Mr. David, what do you have to say?
I would agree with Mr. Mullen on that.
Okay, well, look, I think Mr. Mullen's position is a reasonable one, considering the protocols at the moment. You've brought Mr. Wentworth here, but I would just
Unless
ask
he's
you
from Canton, and then he can just go home. I mean, if he's from
to-
Lynn, he's probably never been to Milton.
But I'd ask that,
Westport.
Oh, Westport, okay.
that his testimony, if you could, Mr. DeLuna, be directed generically to agritourism, and not dealing with over specificity on the operation at Thea Nursery and their revenues and all of that stuff, because that's kind of backdooring evidence, which I don't think we have.
Well, he's also open to questioning by you as to the scope of agritourism.
Sure.
In Massachusetts.
And I think
its
for
endorsement.
that purpose, we're delighted to hear from Mr. Wentworth. Mr. Wentworth, come on up. And if we could confine this for, how long do you think your presentation will be?
Thank you for the courtesy, I appreciate that.
Sure. Thank you for
I mean,
coming.
I'm just going to speak very briefly. I have been to Milton before, but it was a supervised visit, so I enjoyed it, though. Thank you.
Well,
Not from
good.
Lynn
Well,
or Canton.
Okay, we welcome you here, Mr. Wentworth. Why don't
Thank
you
you.
just tell us your name
Sure.
and your position, and we're delighted to hear
Yep,
from you.
thank you. My name is Jason Wentworth. I'm the Assistant Commissioner for the Massachusetts Department of Agricultural Resources. I'm a Westport resident, and I'm happy to be here to talk a little bit about, not about this specific case, obviously, but agritourism in general.
Thank you.
It is, as you may know, I think back in the 80s, and maybe Frank can correct me on this, that we were
He
losing.
would know, he's
Yeah.
been around for a long time.
Yeah. We were losing open space in the state. I think it was about 10,000 acres a year. until the state implemented what's called an agricultural preservation restriction to secure farmlands in perpetuity and to make sure that there is a place for farmers and growers in the state, recognizing their role in protecting open space and providing agricultural products like nursery plants and food to the public. That's the state. I think I'm sure that about 50 or 60 or maybe 100 years ago, there were probably a lot more farms and nurseries in Milton. I grew up in Malden. There are no farms in Malden, I believe, at this point. If there are, I wasn't aware of them. But in Westport, there are, and obviously.
Senator Markey has a farm in Malden.
Okay. I'll have to ask about that. So, one of the things that farmers and growers in the state have been struggling with is the ability to develop income streams that jive with agriculture. And one of the ways that this is happening is agritourism, whether it's setting up a farm stand on a farm that sells not just farm products, but maybe pre-made, value-added products like honey. We've all been to farm stands. We've all gone apple picking with our kids or grandkids, and have enjoyed those opportunities. That's agritourism. This is a very growing, a large and growing sector of the agricultural economy, and it's I don't have specific numbers as to how many people we've managed to keep in agriculture because of those opportunities, but I would say that it's significant, and also it's probably more responsible than anything for the stoppage and losing farms at this point, but also the prevalence and popularity of places like Pick Your Own Apples and farm stands throughout the state. I have some experience in testifying in front of boards and commissions about these cases. I spoke in Westport in my previous role as an executive director for a local agricultural partnership when there was an issue with an abutting neighbor for a vineyard. And they were having a summer music series. The neighbor didn't like the fact that there were cars rolling in. The actual owner of the farm did a lot of work to mitigate any traffic issues. They limited the number of cars. They set up a system of pre-selling tickets to make sure that there was nobody getting turned away at the door, and thus preventing additional traffic. They did noise studies, voluminous amounts of noise studies. And yet there's still a problem. However, the law states clearly that because they're selling their product, their own wine, it's an agricultural product, and the use of this facility is allowed in that way, provided it's not in contradiction to existing laws. So I can't speak on the affidavit, the 2012 affidavit. I can say that I took a walk around, and there is agriculture happening. Obviously with nurseries, you're having the spring. Obviously, is the busiest time, but they're certainly bringing in Massachusetts-grown Christmas trees, Christmas wreaths. And I believe that the Holiday Boutique, the most significant source of income on that particular day is Massachusetts-grown agricultural products. So I believe that there may be ancillary activities happening on this particular day, but they are adding value to the people's experience enjoying agricultural products and the ability to access agricultural products. I often say to residents of Westport, I actually moved down there from the city, so I went down there by choice. I wasn't sent down. And I often say, you enjoy driving through these neighborhoods, these streets, and there aren't big billboards or giant lights or housing developments that are right up to the edge of the street. The reason why that is like that is because of agriculture, because of farmers. They're stewards of the land. They're using the land for the benefit of not just their family, but their employees, their people. They pay taxes, they employ local residents, and they do preserve space. You know, perhaps with a municipality like Milton, with not as many businesses like this, it's maybe a different story. But it's certainly, you know, I'm sure that you have friends and neighbors that are very happy to shop in a small business, a family-owned business that's right down the street, as opposed to going to a giant box store. And I think that that's something that is the intent of the law, intent of these Mass General laws, to promote agriculture, to maintain the integrity of Massachusetts agriculture. And you know, again, I want to thank you for allowing me to say something briefly, Chairman Leonard, and through you to the board. And I appreciate the opportunity.
Great. Let
Thank
me
you.
just see if my
Yeah.
colleagues have any questions of you. Mr. Mullen, do you have any questions of the Assistant Commissioner?
Yeah, let me apologize. I think I called it the Department of Food and Agriculture.
I think
dated
that was our
myself.
old name.
I know.
Yes.
Sorry for
Right.
that.
Yeah.
What is the relationship between the Agricultural Preservation Restriction Program and agritourism, or is there any?
No, there's no-
You
I
were
mean-
just using that as an example.
Yeah,
of
so
how
it-
you've been playing offense on trying to preserve.
It's an example of, and I actually, you know, it's funny, kind of serendipity. We just came out of a process to develop a Massachusetts-wide food plan that brings together stakeholders from not just the Department of Agricultural Resources, but also the Department of Public Health, the Department of Conservation and Recreation, legislators, community members, to figure out how, not just for the sake of farmers, but how can we make local agricultural products, particularly food, more accessible. The APR program came out of the 1978 food plan, and that was an innovation that was born out of necessity. Agritourism is certainly something that is born out of necessity. In addition to providing, again, that additional ability to create revenue and to create jobs, you know, you also have the ability to secure open space and provide greater opportunities for the Commonwealth, citizens of the Commonwealth.
Are you familiar with the New Hampshire case?
I'm not.
Okay, so this has gotten a lot of attention in New Hampshire. It's been in New Hampshire Supreme Court. Let me ask you, are other municipalities struggling with how agritourism is dealt with from a zoning perspective in the Commonwealth? Or are we the first?
No, certainly not the first. I think to answer that question, we have, and actually we have a representative from the Mass Association of Ag Commissions. There are what are called municipal agricultural commissions in quite a few towns, and actually the number of towns that have these commissions is growing. It's a significant method to take issues and prevent them from getting to the level where they're in litigation.
Yeah.
And so I think you know, this is, again, is born out of a recognition that agriculture is, for many communities, ingrained, and you do have people that move into locations and they're not familiar with the activities that surround agriculture. Well, you know, certainly everybody has the right to discuss the issues, and agricultural commissions are very important in providing the agricultural community's response, but also being able to interface with select boards, boards of health, you know, to prevent issues from getting to a lawsuit.
Got it.
Yeah.
So this is interesting. I think we've learned a lot about agritourism. I think it would be very helpful. I'm not prepared to really, let's hold that for the deliberation, but I think it'd be very helpful for boards like ours, and I'm sure other boards, for some guidance from the department about what agritourism is and how municipalities might want to deal with agritourism from a regulatory standpoint. Because I think what's happening here is, I mean, this is very interesting, and I know that the Commonwealth has put a lot of emphasis on this. It sounds very worthwhile. But I don't think municipalities are really well suited to dealing with it when it's a new issue. And we look to past precedent. We really don't have any past precedent. So I know the three of us, we read the New Hampshire case. And I was a little surprised to see New Hampshire ahead of us. You know, So that was news to me, but it was interesting to me, and I know it was interesting to my colleagues. I think it would be a good service, and I'm sure that the Mass Municipal Association and others would be extremely interested in what you had to say and how agritourism can be dealt with by municipalities and maybe get out ahead of this. So that's just a thought, a recommendation. I think it would be grateful. It'd be interesting, but it will also be helpful for a town like Milton, and I'm sure other towns that have even more agricultural activity than ours. But that's the only observation and the questions that I have.
Okay, Mr. Dable, do you have any questions?
I guess I have one question related somewhat to what Mr. Mullen was asking, and the New Hampshire case that he was referring to, for example, indicated that the New Hampshire statutes do have a definition in it of agritourism. Have there been any bills filed at any time in Massachusetts to include the concept of agritourism?
You mean to codify it, or?
Well,
Yeah.
under, like, to relate it to the definition of agriculture, or otherwise to include it in the statutory framework? or-
You know, I think, do you want to?
Bill on the Hill now, I
Yeah.
believe.
And there is pending legislation. Do you remember who filed that?
The activity of
Yeah.
agricultural commissions?
Yeah.
The president of the Massachusetts Agricultural Society. Do you have a?
I'm not may I speak off the record?
No, you have to speak on the record if you want
Well,
to.
I'm not, just for general information
Okay,
for you.
The legislature.
that's all right. You can't be,
I would say
you can't
that
be heard back there.
I've heard that the law is somewhat nebulous or somewhat open to interpretation. It might be intentional because there are, I mean, not every incident or instance of agritourism is the same. And I think that perhaps it does put some unfair burden on municipalities. I grant you that. But I think it's because, you know, we don't live in a homogeneous society, both in what we're growing and doing as far as professional, but we also have very different topography and climate. You know, so the things that are happening in Berkshire County, Pioneer Valley, are significantly different in a lot of ways than what's happening in places, you know, places like Dartmouth or Westport, or maybe even Essex County. So I think the law is particularly open because of that diversity of what's happening in the fields. And again, maybe that does cause problems sometimes, and, you know, I can certainly discuss that with the commissioner and with certain stakeholders about how we can figure out a way to make it easier for municipalities and provide some guidance.
Great. Thank you.
Hi, my name is Laura Sapienza-Grabsky. I'm the president of the Massachusetts Association of Agriculture Commissions. And perhaps what could help you is that the definition of agritourism, according to UMass, and if you can Google umass.edu on definition of agritourism, agricultural tourism merges the world of travel and experience of farming and our food system. Agritourism can be a farm-based accommodation, meals, activities, farm festivals, events, and retail activities where the traveling public interacts directly with the farm family workers. Now, I've worked in the food industry for a number of years, and I've done on-farm venues. I've worked with many farm stands across the Commonwealth. I can tell you that the activities that this particular business is looking to do, their nursery, is common at many farm stands and many areas. They work in activities to bring the public in so that they may sell their Massachusetts products or other farm products. So it's like combining a service to the community to bring them in to be part of the farm family. So, but if you need a definition, it's right online.
Thank you very much.
You're
We
welcome.
appreciate you coming.
Excuse me, could you spell your last name, please?
Sure, it's a mouthful. I'm Sicilian and I married a Polish guy, so don't excuse me. But it's Sapienza, Sapienza -Grabski.
Just like it sounds.
Yeah,
G-R-
Sapienza Grabski,
Yes.
GR.
ABSKI.
Okay.
Thank you.
Thank you very
And by
much.
the way, we are trying to work with some of your members of your community to talk about an agriculture commission.
Great.
So, thank you.
Thank you for coming tonight. Thank you, Mr. Wentworth.
Thank you very
Appreciate
much.
it. If you're driving home, have a safe
take
trip.
it slow. Thank you.
Yes, please.
Yeah, appreciate
Mr.
it.
Chair, if I may,
Mr.
since the
Gordon.
New Hampshire case was brought up, the New Hampshire case specifically dealt with weddings on lands, okay? And it specific, pardon?
We read it.
Okay, and it specifically looked at the definition of agritourism in the New Hampshire code. All right, we don't have a definition, so really, we don't have a codified definition. So you have to take a look at it a bit broader. Now, having said that, Tuesday night, I was in front of the Salisbury Board of Appeals, specifically on that issue as to whether or not weddings would be allowed as a matter of right in the farms in Salisbury. And the Board of Appeals decided, yes, the weddings would be an appropriate activity on a farm venue in order to promote the farm. So,
Okay, thank you, Mr. DeLuna.
thank you.
I understand that Mr. Prondak wants to briefly address the board.
If I may.
Please.
Good evening, Joe Prondak, Building Commissioner. So certainly no one wants to be here on this issue, and nobody wants to be labeled the Grinch that stole the holiday fair. But just, again, very briefly, you know, we never told Thayer Nursery they could not have the holiday fair. We told they could not sell certain products. They chose not to have the holiday fair based on that decision.
Well, I don't know whether that's true or not. They
My opinion.
may be up in the air. Go ahead.
The reason we told them they could not have those certain products is because there's a court order that says they can't have those certain products. And I was assured by town council that that was the right decision. Having said all of that, and looking to a solution, especially where the abutters have even looked toward a solution to this matter. But to back up on that a little bit, I checked with town council as instructed by town administrator. The Board of Selectmen do not routinely offer one-day permits for craft fairs or any of the, they simply don't, it's not something that they do. So as a suggestion from myself only, if the board were to look at this very limited one-day, 6-hour event with a very limited product list as was suggested by Thayer Nursery at the last hearing, perhaps they could look at it as an accessory use, given the limited nature of it, and overturning my decision based on that might be an avenue.
Okay.
That's all I have to say.
Okay, thank you, Mr. Prondak. We appreciate that. So it's 5 after 8. Let's go back into deliberations and see if we can get this. Of course you can. Mr. Johanning, come on up here. Thank you, sir.
Phil Johanning, 23 Parkwood Drive. I guess I would disagree with Mr. Prondak on this. You know, as I pointed out during the last meeting, there's always creep going on at Thayer. And so a decision by the board to grant this type of activity as being consistent with the law of Milton or consistent with the rulings of the court, I don't know that the board has the authority to grant a one-day type of thing. You know, it's either consistent with the law of Milton and consistent with the decisions of judges, or it's not. And that's the way I see the charge of the board. And so for this board, I see only yes or no on the decision of Mr. Prondak. I think that creep has been consistent, and any kind of inch granted turns into a mile. And, you know, I want the community to enjoy the day. I think that based on the input from the Board of Selectmen, that they could perhaps find a way to help Thayer have this event on one day. And we would be perfectly happy with that. It seems to me that the Board of Selectmen takes little risk when they know that the abutters will not oppose anything they do for this one day. And I think it would be well worthwhile for Thayer to approach the board and ask them to give that permission. But for this board to do it, I guess I would be opposed, because it is inconsistent with the law, it's inconsistent with the judge's decisions, and furthermore, as Mr. Dunn pointed out, if there's a protection by, of Thayer given by the Dover Amendment, it does not extend to vendors operating on their site. It extends only to Thayer, or to the owners of Thayer. So, it doesn't make any sense for the board when the Milton zoning bylaws say that in a Residence A or AA district, commerce cannot be conducted, and for these people who have no grounds to protection to suddenly start engaging in commerce would be wrong, in my opinion. Thank you very much.
Great, thank you, Mr. Johannan, we appreciate your comments. So let's go back into our deliberations here. Mr. Mullen, do you
Thanks,
you
John.
want to be heard?
Thank you. So, thanks, everybody. Appreciate it. So we learned a lot about agritourism. I find that very interesting, and I hope that the department follows up on that, because I think that's an increasingly important issue for boards like ours, in towns like ours. We learned a lot about the Dover Amendment. I don't think this case is really about the Dover Amendment. I don't think we're prepared to make a judgment on whether or not the property is currently protected by the Dover Amendment, because we didn't hear any evidence on the changed circumstances from the 2012 facts. And I, too, read the case as the case and the rulings in the Superior Court as, and the permit that the 2012 board granted as being focused on the commercial enterprise, the landscaping business, and not the nursery business. And I'm happy to have a conversation about Dover Amendment applicability to the activities that are currently happening at the property. I just don't think we heard that. I think we heard a conversation where it was assumed that it was so, and therefore the best argument was agritourism. So that's what I think we had. With respect to the specific matter in front of us, I really feel like there's a big difference between, let me say this. Those people, I think the Board of Appeals is consistently saying we don't want to micromanage. We're not micromanagers, and by that I really want to reject the idea that we would have to specifically articulate every a single use that was happening on any property in the town. Rather, what the board had indicated in the 2012 permit was there was an instruction that you couldn't sell items and goods not reasonably incident or accessory to the nursery. That was the ruling, and that was the ruling of the court. So to me, this case really turns on that. What is reasonably incident or accessory to the nursery use? And here's where I come out on this, and this is where I'm going to disagree with you, sir, although I have respect for you. I think there's a big difference between the sale of products and the ordinary customary trade, meaning every single day selling products. I don't think that's reasonably incident reasonably incident or accessory to the nursery use. But I heard evidence, and I know from my own activity that it is reasonably incidental or accessory to nursery use to conduct the kinds of activities that have been requested, and that is a one-day annual event designed for the holiday that happens to sell homemade products. That's very customary at nurseries in Massachusetts. It's very consistent with what we all know to be true. And it seems to me that that's very consistent with both the 2012 permit and the court rulings. So I think the important distinguishing factor is that this is a limited activity, one-day event around a holiday that involves homemade products where steps are taken to mitigate the impacts, that also happens to be supported by the neighbors and has the unanimous support of our Board of Selectmen. I think all of that is very important, and very important facts that go into this hearing, all of which permit me to support an overruling of the Commissioner's determination that these products cannot be sold on those facts. In other words, I would narrow the situation. We're not asking, and it hasn't been asked, the petitioner has not asked to sell these products in anything but the limited circumstances for which the question has been raised. And it seems to me that that's consistent and it reasonably incidental or accessory to the nursery use, and it's something that I would be prepared to support on that basis. Now, I spent some time looking at the general bylaw of the town and did not find a specific section. Section 37 of the general bylaw permits the Board of Selectmen to issue a one-day permit for yard sales and the like. I know this is not a yard sale. This is like a yard sale, I guess, in some ways, given the way that it's conducted. There's also a section in that section that speaks to the Board of Selectmen making a finding that third parties can sell the product on the premises and it not have to be the homeowner's goods if it's for charitable uses. And that also was raised here. But I feel like asking the Board of Selectmen to have a hearing to arrive at the same place where this board can arrive today to accomplish this now, where we don't have large opposition and where this can be very narrowly tailored to the purposes for which it's been designed and asked, is really putting form over function, and I wouldn't support that. So for all of those reasons, I'm prepared tonight to vote to overrule the board, the commissioner on those narrow grounds and support the activity.
Mr. Deba, please.
Okay. You're saying for a 1 day a year?
Yeah.
1 day a year,
Yeah.
okay. I started out, I think, probably in the same place that Mr. Mullen started out, with looking at the special permits, even though the major argument that Mr. DeLuna made was agritourism. Did not find anything in the special permits or in the court order inconsistent with Mr. Prondak's order, and also read a lot of cases, both Superior Court and Appellate Court cases, none of which dealt with the specific items that we're talking about here, but also none of which, as Mr. Mullen was pointing out, I think, dealt with the idea of a 1 day per year fair or festival either. As far as agritourism goes, which I think would a ruling based on agritourism would be a much broader ruling with much more implications for the town and other businesses in the town. I really think that has got to be, in the first instance, which is why I asked the question, a legislative issue. I think if we are not a legislative body, if agritourism is to be included in the definition of agriculture, which as broad as it is, I do not read it as including agritourism at this point, the way I read agriculture. I think that's something that's got to be handled by the legislature. The applicant, I'm sorry, the abutters have indicated that if the Board of Selectmen granted a 1 day permit, that would be acceptable to them. I think they're concerned about the effect of the Board of Appeals entering some kind of an order which might have a broader impact and more than a 1 day, 1 day a year permit to hold a Christmas fair. I'm not sure whether the board could do it, but if and maybe my colleagues can help me on this, if presumably, or hopefully, I guess, at some point in the next year, some kind of another procedure could be pursued, which would give a more definitive answer to this question, and perhaps we could, as Mr. Mullen suggested, issue a permit for a 1 day order for this year. I don't know, perhaps to be revisited next year, or perhaps in the hopes that something else could be worked out or some other procedure could be followed to deal with it in future years.
Okay, well, I appreciate that, Ted. Thank you very much. I've given this a lot of thought as well, and these cases are never easy because they're a combination of trying to run a business in a reasonable way, and from the neighbor's perspective, there's a long history here of decisions by the Superior Court restraining actions of Thayer Nursery that have not been permissible under the zoning bylaw. I think to start out with, and I understand when you're dealing with your house and you're dealing with your business, those are highly emotional issues. I know from personal experience. But I want to start out on a happier note, if I can. And I really want to thank Joe Prondak. Joe is in a very, very difficult place here. He has to enforce the zoning bylaw. He can't make it up. He can't make exceptions to it. He has to enforce it as he reads it. He's our first line of defense, I always say, and it's very true. I've been chairman of this Board of Appeals for over 16 years, and I really think that Mr. Prondak has been one of our finest building commissioners. Sometimes we disagree with him, sometimes he disagrees with us, but he always enforces the zoning bylaw, I think, in a tasteful and an appropriate manner. And I think Joe does a terrific public service on behalf of the town. I want to thank you for that, Mr. Prondak. We couldn't operate without you. And I think Mr. Prondak's comments here that he made a few minutes ago indicate, as we know, that he is sensitive to the effect on businesses and people in enforcing the zoning bylaw. He does a terrific job. I think, as Mr. Mullen said, from my perspective, the key to this particular appeal is to look at the specific facts that we're dealing with here and not to overgeneralize. I understand that Mr. Joe Henning's position that we have certain decisions of the court, and he wants to protect his interests under those decisions, and I understand that. It's a legitimate concern. We here are dealing with one very specific request, and that is to conduct a Christmas fair on December 6, 2015, from 10 a.m. to 4 p.m. With this artisan sale of goods. And when I looked at the artisan sale of goods, to me, the types of homemade or personally made items that are reasonably consistent with fairs. I looked at the internet, I looked at some of the materials Mr. DeLuna submitted, and I find this type of the sale of honey, which may be agricultural, the production of sweaters and scarves and that type of thing, carved artifacts and the like, are traditional items that I see at fairs all over Massachusetts. And I think it's important to mention that and to find that, because if Thayer Nursery was saying we're going to sell 18-karat jewelry there, we're going to have Bernie and Phil's there selling furniture, or selling extravagant pieces of art that you see at some fairs, that's not consistent with my view of what artisans do at a Christmas fair from what I've read. So it's very important to keep that very much in line. And it's important to keep in mind that this is a one-day event for a limited number of hours. And frankly, if Thayer Nursery said we're going to have a Christmas festival for the 6 weeks before Christmas, I would be adverse to that. But that's not what they're asking for. They're asking for very discreet and limited relief here. And I think that any decision that this board writes is going to have to deal with and emphasize that this is a very specific issue. I think Mr. Joe Henning and Mr. Rowe, who's unable to be with us tonight, I think they were magnanimous in suggesting that they would not oppose the selectmen granting a limited exception for a Christmas fair, even including these artisans. I think that was very helpful. I think it was very thoughtful. I understand Mr. Johanning's position that he does not want to adversely affect the decisions of record of this board, and I don't think we have to do that in order to grant the limited relief here that we're asking for. When we decide these cases, and I think the first test we always apply, at least I do, and I know my colleagues do, it's really what's in the best interest of the town of Milton. That's really the key. If it's not in the best interest of the town, no special permit, no variance should ever be granted. But then the second question then is how does it relate to the citizens and families of Milton? And thirdly, how does it relate to the applicant? And are all of those factors consistent? We have a record here that Thayer Nursery has been having this type of fair for 11 or 12 years. I haven't had the privilege of attending that fair, principally because I guess my children are old. But if my children were younger, probably I would have been there and I would have seen what's happening at the fair and observed that it was for the sale of limited-made artisan goods. And I think Mr. DeLuna, or it may have been Mrs. Oldfield, I'm not sure, made the point of how the artisans actually interact. This is just not a crass commercial business. They interact with children and families, and that's part of the educational experience of attending this particular Christmas fairs. I think we understand that the neighbors, there is some imposition on the neighbors as a result of this, and what we have to do is how do we balance these competing interests? And from my view, I thought the selectmen who really speak to what's in the best interests of this town from a public interest perspective, they individually unanimously supported this fair, but they did it in a thoughtful and tasteful way, not indicating that this is going to open up Thayer Nursery for harvest fairs and harvest moon festivals and anything else like that, because I don't think that's permitted by the zoning bylaw. But Miss Katie Conlon particularly writes that not only has it been a tradition, it has, and it's going to have an adverse impact on the neighbors, but she thinks that the holiday fair will bring joy to many Milton residents and their families, and it will instill joyful holiday memories in the children. And I think she's right, and she asked this board to grant limited relief to Thayer. So in that sense, I agree with the selectmen. I think they are speaking in the best interests of the town. And I think that by granting a limited exception to allow just this particular use with the particular types of artisans that are defined for the limited hours, I would be prepared to support that. And I think in doing that, Mr. Johanning and Mr. Rowe, while they may be disappointed in granting this type of relief, we don't have to grant the relief with any great specificities as what's ancillary to the operation of a farm or anything like that. And I understand my friend Mr. Mullen's comments in that regard. I don't think we have to go there. We have a representation by Thayer Nursery that this is the type of artisan activity that's going to take place. Santa's going to be there, the Grinch is going to be there, photographs are going to be taken, hot dogs are going to be eaten. But if we found that after the fact, people are buying automobiles there, or there are wheels of fortune there or something, we'd be deeply disappointed. And I wouldn't be inclined to grant further relief in the future. Katie Conlon suggests that, well, maybe we should amend one of the special permits that we've granted. I don't think we amend anything that we've granted or denied. All we have to do is make a single limited exception for this particular use at this particular time. And I don't think we have to get bogged down in what's very technically covered under the Dover Amendment and what isn't. The only thing that I'd add that my colleagues haven't mentioned is I would ask, and I know I would put in any decision, that Thayer Nursery does what it has in the past, that they would go to the chief of police, describe, make sure that the chief of police is familiar with the number of people that they expect and all of that. Thayer hires wardens, I think Mr. Oldfield mentioned, but it may be another name you used, to make sure that people don't park in other people's driveways or park on their lawns or whatever. And I expect that to happen here. And if the police chief suggests that more than one policeman is necessary, that for whatever reason, I would just ask Thayer to abide by whatever decision the chief of police makes to protect the neighbors' properties, and equally to protect the safety of the public attending the fair, that kids don't get too close to fires or whatever is good police practice and good fair practice. And I know you'll do that, and I think it's, I would never get involved in delineating that in over detail, but I think that should be one of the conditions that's attached to this. So, Mr. Mullen, do you have anything else to say?
I agree. I did make a point about the fact that steps had been taken to mitigate the impacts through the use of traffic control and the like in the past, and I think that's an important fact. I definitely support a finding that those steps should be consistent with what's done in the past, as may be determined by the chief.
Or what the chief may decide
Which
is
makes
needed in the
sense,
future.
and is consistent with what we've done in the past. Maybe we'll have a conversation here. I mean, to me, this case rises and falls, as I said earlier, on what's reasonably incidental or accessory to the nursery-related operations, which is consistent with what we said in the past.
Yeah, but you don't have to go that far. You can say
yeah,
consistent
that's my
with
question.
a one-day Christmas fair. That's
Yeah.
what it's consistent with, and nothing else, and don't go beyond
So,
that.
so I want to talk about that.
Yes, please.
So the ruling, so where we're arriving here is it's a one-day Christmas fair. The question I have, and I think a question that Ted asked, is it a one-day Christmas fair in 2015 so that it wouldn't be repeated in 2016? Because I'm not sure I want to be back here in 2016 with the same set of facts. Put another way, what's the difference between a 2015 fair and a 2016 fair? Understanding that the legislature may, other than perhaps the 2015 fair doesn't go well, and the mitigation that's been mandated by the board, it is non-compliant. That would be an enforcement action. Let me be more articulate. I understand that the legislative body, the town meeting, could, or the Commonwealth's legislature could make a ruling here which would alter this conversation, and that's a chance all the time. But for me, what this is an annual event and not an event that happens to be this year. So my question is whether or not we all agree on that, because I'm not sure that we do.
Well, I think the problem is we have no experience with it. I don't know what's happened at this fair except what people have told me.
Right, I know, but with all the limitations about which that we've discussed, limited artisan goods, take steps to mitigate the impacts, a holiday fair of the type described in the application, wouldn't it be an annual holiday fair rather than a holiday fair on December whatever 2015? In other words, we're not granting a permit; we're granting relief for the permitted uses in the land.
Well, yeah, but I think by 2016, Jeffrey, the planning board may have jurisdiction over over this.
They might.
And so why would we do anything that would bind the hands of the planning board?
I don't want to.
If we don't have any jurisdiction.
I wouldn't want to, but I don't know what those facts are going to be.
I don't either. And I'm apprehensive. I understand what you're saying. We don't want to do this every year. And I agree with you. I just don't I don't know whether it's appropriate under the circumstances that since this is the first time it's happened, that they've come to us, that we should extend it as something that's going to go on in the future as long as it's consistent with us. Because I don't know what the planning board thinks or wants or intends to do in this matter, and I think maybe they should take it up and not us. Ted, what do you have to say?
Well, I was just going to say it also that, in looking at the papers and the record, it was a request for this specific year that was made, and it was the denial of the request for this specific year that was made, and that's what's being appealed. And so I don't know whether we really have, whether it's before us for future years.
Well, I don't know whether it's before us or not, but I don't know that we have to go there. But what I think, Mr. Mullen, is that if you assume that we still have jurisdiction of these matters, and when we near 2016, if we're all still here,
We get back together.
then a hearing on a similar fare, presuming 2015 goes well, and it's gone well for 12 years, I can't imagine why it won't, then would be a rather perfunctory hearing, and we wouldn't have to go through the extended hearing that we've had at this time.
We get paid overtime for that?
No, I don't think so. Ted?
I assume, you talked a bit about some of the, what was discussed by the appellants as to what they had done in previous years, and that would include, I think it was, you said, parking on parking on just one side of the street to make sure that the traffic could get through and,
Right,
Okay,
it
so-
just seems to me that, I know nothing about parking for fares, and the police chief and his lieutenants, they know exactly what should be done.
Right.
And I say leave it to Chief Wells, and I'm sure if people are not compliant for whatever reason, that the chief and his lieutenants would be available to deal with the situation.
Yeah, I agree. You know, you get into trouble when you list them because, you know, you may accept something and then it
Right.
does, you know?
Yeah,
I think the evidence was that is exactly what we heard, Ted, but I'm sure there are other things that were going on as well. I would like to say something like steps taken as have been done in the past, as may be mandated by the chief of police, something like that. And
maybe the
leave it to-
fire chief as well.
as appropriate, yeah, I'd be fine with that.
Mr. Oldfield, did you talk with the fire chief as part of this fair, or
I
is he?
haven't in the past, but I can make it a point to do that.
Well, okay, why don't you do that, just to protect everybody here. So, if nothing further is to
Nothing
be
further,
said,
Mr. Chairman.
all those in favor of granting a limited special permit for the reasons that we've discussed, with the requirement that they are, that talk with the police chief regarding parking and safety, and talk with the fire department regarding similar considerations, and also to be compliant with their recommendations, say aye.
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 Well, congratulations on your limited exception. Thanks for everyone, and I mean this sincerely, even though these can be difficult hearings, for everyone's civility and willingness to discuss the issues openly. And Mr. Johanning, I want to thank you for your comment about not objecting if the selectmen granted it. I know you're
I
preserving.
think this is equivalent.
Yeah.
With the restrictions that you've outlined, I think this is a fair compromise.
Well,
I don't object.
Okay, thank you. I hope you feel that way, and I hope the fair goes well, and that you have a lot of children and happy Milton residents there. So thank you for coming,
you.
ladies and gentlemen, and have a good night. Thank you. Thank you all. Okay, thank you, Joe.